Good afternoon. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society, and it's my honor today to welcome you to the Society's lunchtime or morning coffee for our West Coasters virtual lecture platform. The Society continues to produce an active series of lectures and discussions over Zoom that we began at the outset of the pandemic. We do look forward to a return to in-person programming when we were able to do so, but we also plan to maintain these virtual lectures as well. It's been very rewarding for us to develop these programs during the pandemic and to connect our programs to many more people and members who might not otherwise travel to Washington, D.C. for the in-person lectures. So this has been a great format, and we look forward to continuing it. Today's lecture is from Professor Kate Masur and is drawn from her 2021 book, Until Justice Be Done, America's First Civil Rights Movement from the Revolution to Reconstruction. The winner of the 2021 Littleton Griswold Prize, the John Philip Reed Book Award from the American Society for Legal History, and the John Now Book Prize in American Civil War Era History, as well as a finalist for both the Pulitzer Prize and the Lincoln Prize. Professor Masur's book is a groundbreaking history of the movement for equal rights that courageously battled racist laws and institutions north and south in the decades before the Civil War. It is a little covered movement, and in her own words, we have missed the struggle for racial equality and civil rights that spanned the first 8 decades of the nation's history, a movement that traveled from the margins of American politics to the center and ended up transforming the U.S. Constitution. Kate Masur is a professor of history, Board of Visitors professor at Northwestern University. She specializes in the history of race, politics, and law in the United States. She has consulted extensively with museums and arts organizations, including the National Constitution Center and the Newberry Library. She was part of the editorial team that created Reconstruction, the official National Park Service handbook. She also was a key consultant for the 2019 documentary, Reconstruction, America After the Civil War, and appeared in the recent film, Lincoln, We Stand Divided. Professor Masur regularly works with K through 12 teachers and speaks with the media on topics including the Civil War and Reconstruction, Lincoln, and monuments in public memory. Professor Masur will speak for about 30 minutes or so, and then we will take questions from the audience. Please submit your questions in advance in the Q&A window of Zoom, and we will get to as many of those as we can. Professor Masur, the floor is yours, and we're delighted and honored you're with us today to talk about your wonderful book.
Well, thank you so much for having me, and thanks to both you, Jim and Jennifer Lowe, for doing the arrangements that made this happen. So let me just start in the usual Zoom way by sharing my screen and playing the... Oh, my screen just went completely dark. Can you?
We have a visual. We have a visual of the book cover.
Okay, good. And I was now. All of a sudden things went dark, and now I'm back. Oh no! Wait, oh my gosh, I'm sorry.
That's all right.
I don't know why this is happening. Hold on, let me go back. Okay, are you seeing right now only the slide with the book cover, or are you seeing the slide and the column to the left?
We're seeing both, I think, the book cover and the slides to the left.
Okay, let me just stop sharing. Okay, I think I'm gonna do this without slides for now because that is too complicated.
Okay.
So let me go. All right. So, and then it's should be okay. So let me just start again. Thank you so much for having me. And I thought for the Supreme Court Historical Society, I would kind of start this talk with the end of the book, which is to say, to start with Reconstruction and the nation's first federal civil rights measures, the Civil Rights Act of 1866 and the 14th Amendment. These two measures were the first time in American history that the United States government put the force of federal power behind the idea that all people were entitled to certain basic civil rights. And in particular, in the case of the Civil Rights Act of 1866, that you couldn't subordinate people based on race, that racially discriminatory laws that subordinated African Americans were now against federal law, and that Congress and the federal government would come in to enforce people's rights if they were being denied at the state level. So the Civil Rights Act of 1866 and the 14th Amendment are really monumental changes in American history. In my book, one of the central arguments I make is that these measures had an antebellum history. That is to say, they were not made kind of invented out of whole cloth in the moment that Congress was confronting them in 1865 and 1866, but that they had a longer term history that we need to know about, both because it's interesting in its own right and because it helps us better understand those really monumental measures. So the questions that Congress confronted in 1866 were not entirely new questions. In the era of the American Revolution, northern states had started to abolish slavery, and the abolition of slavery in the northern states set in motion debates, often at the state level, about race, rights, citizenship, and equality. Black and white Northerners actively discussed and debated in newspapers and pamphlets, in state legislatures, in courthouses, and other places whether the United States could ever be a multiracial democracy. So they were asking questions, again, in the antebellum North, where slavery had been abolished. Could Black and white people ever coexist in this country in conditions of equality? Was it acceptable to adopt policies that subordinated people based on their race, based on, that is, like the color of their skin, their texture of their hair, or their family's continent of origin, right? Let's say people of African descent as opposed to people of European descent. So these were live questions in the free states before the Civil War. And in this book, I developed the argument that across the decades before the Civil War, Black and white Northerners engaged these questions about the rights of free African Americans, and they moved their debate from the margins of politics into the mainstream and eventually into the Republican Party, which becomes the most powerful, most important political entity in the United States in 1860, right? And kind of with the election of Lincoln and then Southern secession. And it is the Republicans then who implement the policies of racial equality at the federal level that we see in the Civil Rights Act of 1866 and the 14th Amendment. So before I give a few specific examples from the book about how this worked, I want to explain a little bit about how my interpretation differs from what generally people already think of when they think about these first federal civil rights measures. So first, and this may or may not, ring true for people in the audience, and I'd be curious to hear what you think when you hear this. But most historians, most people who think about Reconstruction, tell the following kind of story about where these measures came from. According to the sort of prevailing story, Republicans in Congress during the summer of 1865 and into the fall of 1865, as the Civil War ended, right, and President Andrew Johnson is in charge, he is the president of the United States, congressional Republicans watched violence and chaos unfold in the southern states during the summer and fall of 1865. They saw white Southerners committing tremendous violence against Black Southerners and white Unionists. They also heard reports from journalists traveling in the South of white Southerners being unrepentant, of still holding, animosity toward the United States government, of being reluctant to accept the abolition of slavery. And so according to this narrative, Congress reconvenes in December of 1865, and they're looking with shock and horror at what is going on in the southern states, and they hammer out a bunch of policies designed to correct what they're seeing, to intervene in what they're seeing. And so from that, you get the Civil Rights Act of 1866, also the Second Freedmen's Bureau Act, and they begin to hammer out the 14th Amendment, which they finally pass a version of that summer of 1866. So in that narrative, which is not, I'm not saying it's wholly incorrect, the vision is this is emergency lawmaking. They're catch and catch can. They're kind of starting from scratch, and they're thinking, what do we do to face this current emergency? And it's a kind of a historical vision in the sense that it's almost as if people assume that they had never thought about these issues before, that they were coming to this for the first time. They're realizing that what the policies that Johnson had put into place were not going to work. And they're just going, oh my gosh, we've got to do something. What do we do? How do we do this? So that's a kind of prevailing view or set of assumptions in the historical literature, that there's really no useful way of thinking about antecedents to those policies. Now, there's another narrative that is sort of comes out of a constitutional law tradition and goes back to litigation around Brown versus Board of Education, I think, in which some scholars have argued that there were worthwhile antecedents to what the Republicans were doing in 1866, and those were in the abolitionist movement. And so what some scholars did, particularly in the field of constitutional law, was they went back and looked at certain major court cases that may have been relevant to the lawmakers of 1866. And they also looked, importantly, at abolitionist treatises. So treatises published by abolitionists talking mainly about slavery itself. So these people tended to be radical figures. They were advocates of a vision of human rights that seems very relevant to us today. Indeed, it is relevant. And they would write about why slavery, human bondage, was morally wrong. And they would advance theories of human rights and dignity and the kind of wrongness of slavery. And some scholars then connected that somewhat tenuously, I would argue, to the Reconstruction amendments, particularly including the 14th Amendment. So they would say, look, you have these kind of ideas out there being put forth by abolitionists about human rights. And now we see, fast forward to 1866, we see that Republicans are going about the business of abolishing slavery and implementing other measures that are going to kind of promote the idea of non-discrimination or racial equality. I think it's, as you can tell, I think it's a very good idea to go back and look at the antecedents and try to figure out what was the history and the kind of ideas that these Reconstruction legislators were drawing on. But I think that it's not, as the recourse to the abolitionist tracts is not as helpful as it might be. I mean, first of all, many of those abolitionists were fringe figures. It's not easy to trace direct lines of connection between those abolitionist writers and the actual Republican legislators who were in power during Reconstruction. And also the ideas that they're expressing are pretty general in terms of, yes, they believed in human rights, but we don't necessarily find explicit references to the kinds of constitutional problems and kind of problems of rights and federalism that these folks during Reconstruction were trying to resolve. And so I would argue that what people haven't really seen and what I'm trying to put on display is that there was actually a much more relevant debate going on in the free states before the Civil War for our purposes than the abolitionist debate. It's related to the abolitionist debate, but it is not identical to the abolitionist debate. And that is we need to understand that the free states were in essence post-slavery societies themselves. And so it stands to reason that they were debating the same questions about race and equality that a post-slavery society would face, a society where slavery had been founded in racial ideologies. They were facing those same questions that the nation as a whole would face at the end of the Civil War. And so we haven't yet been able to fully see this debate about questions of race and equality in a free society that were, I would argue, far more relevant to the questions at hand at the end of the Civil War than we should have been able to see them. We not only, when we see this debate, which I'll give some specific examples in a minute, we not only see that people were talking about the same questions of race and civil rights and political rights that they would later confront during Reconstruction, but also that some of the very same figures, some of the same exact people who were involved in that antebellum debate over civil rights were then actually legislators in Congress who were making these decisions during the Reconstruction period. So these people, there's a much more direct connection that we can draw from these debates about race and civil rights in the antebellum period to what actually happened in Congress during the 1860s. So one thing I want to add is that in order to see this intense Northern debate about race and civil rights, we need to go beyond the traditional sources that constitutional law scholars typically use. So those sources, as I mentioned, tend to be major court cases and published treatises. But the reality is that a lot of the debate about race and civil rights in the antebellum North didn't happen in those spaces, right? So it did not happen in abolitionist treatises. Many of the issues did not make their way into court, certainly not to high-level courts where the decisions would be readily available to constitutional researchers. The people I write about often didn't get their cases into court. And so this debate, even if it was rendered in constitutional terms, was often engaged at the state level, at the local level, in state capitals, in the form of petitions to state legislatures, in debates within state legislatures, in newspapers, and in the kind of broader public discussion. So in order to kind of illuminate this conversation, I needed to go beyond the traditional sources for constitutional law and look at this broader array of sources that illuminate kind of social and political history. So let me turn to two kind of central examples from my work. And one is a state level example, and then one is an interstate kind of example. And now this is where I really wish I could show the slide. So let me, should I try it again? What do you think?
Sure, try it again, Kate.
All right, let me give it a quick one more try. I don't know why.
There we go.
Okay, so what I'm going to not do is go into slideshow mode because that's where we really went awry.
Okay.
So let me start with the state level. So as I mentioned, a lot of these conversations were going on at the state level, not the federal level. And I can go into more detail about why that was the case. But one of the central venues for the debates about race and civil rights in the antebellum period were state level anti-Black laws, which were sometimes called Black laws. So particularly the fast growing Midwestern states of Illinois, Indiana, and Ohio had adopted from the beginning of their statehood laws that explicitly discriminated against free Black people. These laws, and I kind of give a few details here, these laws were passed by state legislatures to discourage Black migration into the states. They were intended to exclude and marginalize free African Americans with the idea that they would be discouraged from coming, particularly from slave states just to the south, so from places like Kentucky and Virginia. And then once they got into those northern states, that they would be kind of forced to the margins of society. So quite literally, these laws placed restrictions on Black legal settlement. They said that African Americans moving into particular counties needed to register with local officials. They needed to get someone else, usually a landholder or two, to put up bonds essentially for their good behavior to say that they would not become a public charge. Some of these laws placed penalties on employers for hiring people who were not properly registered with local officials. These laws also prohibited African Americans from testifying in court cases involving whites. As state public school systems developed in these states, they declared the public school systems for white students only. And then by state constitution, voting was for white men only. So these were repressive laws designed in the absence of slavery, by the way, in places where slavery was essentially not legal. I mean, certainly not legal. And Illinois was a little ambivalent, but basically in places that were becoming places where no slavery existed, where a regime of sort of racial apartheid was attempted. The civil rights activists who I write about for this period mobilized against these laws. And this we see from the 18 teens onward in growing strength and increasing kind of integration of this movement into party politics. So I want to give a couple of examples here of how that worked. The Black populations of these states tended to be very small. So in Ohio, for example, the African-American population in this period remained around 1%. As the state's population grew quite dramatically, the Black and white populations grew at around the same rate, notwithstanding these discriminatory laws. And so this is a very small population where Black men are not able to vote. So they need to find ways of intervening in politics and persuading white people that we need to repeal these laws. One of the ways that they went about doing this was through petitioning the state legislature. So on your left here, you see a petition form created by a group of African Americans who met in 1837 and developed this petition that was going to be signed by Black residents of the state of Ohio and sent into the Ohio legislature, asking the legislature to repeal the laws. And it's a just artifact of 19th century politics that the petition is published in an anti-slavery newspaper because people use these petitions published in newspapers. They would cut them out, stick them physically on a piece of paper, and then add signatures, and they could add pieces of paper as a list of signatories got longer and longer. And so that was the purpose of publishing a petition in a newspaper. White Ohioans who supported repeal of the Black laws also mobilized petition drives to encourage the legislature to repeal those laws. David Jenkins on the right was one of the leading Black Ohioans of the time. He lived in Columbus, and he was involved from the beginning in this campaign to repeal the Black laws. In the 1840s, he became editor of the Palladium of Liberty, which was a short-lived but really, really interesting Black newspaper that also called for repeal of the Black laws. And so in a variety of different ways, Black Ohioans and African Americans in other places mobilized for repeal and tried also to, one of the things they had to do was persuade white people to get on board for repeal of these laws. Now, Ohio is the biggest success story in this in terms of the Midwestern states, because the movement to repeal the laws ends up entering politics in the form of coming in as part of a third party movement called the Liberty Party, and kind of increasing awareness about the exploitative nature of these Black laws, and eventually through interesting party maneuvers gets enough people from both of the other major political parties to repeal the Black laws in 1849. So this state level struggle actually succeeds in repealing these repressive laws in 1849. Now I'll turn quickly to the interstate issue. Another one of the problems that came up for African Americans in the free states, particularly on the East Coast, was that many Black men worked as sailors, going up and down the coast, working on ships in the coastwise trade, it was called. So ships would go up and down the Atlantic coast of the United States, often bringing staple crops from the southern states up into New York, sometimes going from there to London. And starting in the 1820s with South Carolina, Southern states began to pass laws that explicitly kind of required Black sailors, whether they were from the North or from abroad, to spend time in jail or stay quarantined, they use that term, on their ships while their ships were in port. And so this is an example here, this affidavit of Joseph Thompson, of a Black sailor who comes back to Massachusetts and gives testimony about what he experienced in a New Orleans jail. He was unfairly arrested in New Orleans. He had been out on the street, wasn't able to show that he had a pass, or no, sorry, in his case, he had a dispute with his ship captain and ended up getting put in jail by that guy, where he discovers, Joseph Thompson discovers, as he says in the affidavit, a continual stream of free colored men from Boston, New York, Philadelphia, and other seaports in the United States who were passing through the jail. And if they were not recovered from the jail by either the captain of their ship or somebody else, they could be sold into lifelong slavery. So the issue of these Black sailors who were highly mobile in their employment becomes a very pressing one for many people in places like New York and Massachusetts, where African Americans come back, give testimony about what's going on, and many white people get galvanized to try to defend the rights of these free Black sailors. Now, in this case, unlike in the state of Ohio, because that's just a single state with its state laws, here we have an interstate issue. And so in this case, it was easier for people at the time to engage with the United States Constitution. The Black laws of a place like Ohio were not understood really by anybody to be unconstitutional under the US Constitution. But an argument could be made, and was in fact made by these early civil rights activists, that laws in places like South Carolina or Louisiana that required Black sailors who were citizens of their home state, of a place like Massachusetts or New York, the laws that required them to stay in place on their ships or to spend their time in port in jail violated these sailors' rights under the original Privileges and Immunities Clause of the Constitution, which is in Article 4, Section 2. And that clause reads, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. And so we begin to see in the 1830s and 1840s, people coming together in especially Massachusetts, also in New York, and making the argument that there's a federal problem here, that the southern states are violating the constitutional rights under the US Constitution of these free Black sailors. And in Massachusetts in particular, they get galvanized to petition Congress to step in. And eventually in 1843, a committee of the United States House of Representatives issues a report on the issue. And that the committee is chaired by Robert Winthrop of Massachusetts, who's the main signatory on the kind of leader, takes the lead of the report. And interestingly, the thing that the report says is, those Southern laws actually do violate the United States Constitution. They violate the rights of Black sailors under the Privileges and Immunities Clause. They violate the rights of Congress to legislate, to have jurisdiction over interstate commerce. And where foreign sailors are concerned, they also violate Congress's area of jurisdiction under the international treaties provision. But that being said, the report also says there's nothing Congress can do about it. Congress cannot step in. They don't think Congress can legislate in this area. They know for sure that Congress does not have the will or kind of the political capacity to legislate in this area right now. And so we see this kind of moment where there's an attempt to bring, to kind of get Congress involved. And although the report out of the House anyway was sympathetic, these congressmen are also saying there's nothing we can do about it. Now, this whole part of the story kind of culminates when Massachusetts sends a man named Samuel Hoare to Charleston to bring a case into federal court. So the other way that you can sort of test or protest an unjust law or try to get a kind of adjudication on the question is to try to bring it into federal court. So the state of Massachusetts sends Samuel Hoare to Charleston, and they send another man to New Orleans too, with the names of Black sailors and the idea that they will bring a case in federal court on behalf of some of the incarcerated Black sailors to test whether these laws are constitutional. And this is in 1844. What ends up happening? both men, one in New Orleans, one in Charleston, get run out of town by the white residents of the town. So Samuel Hoare's case is particularly kind of well known. Charlestonians come along and say, we can't guarantee your safety. You better leave. You certainly can't bring a case into federal court here. And Hoare gets on a boat and heads back to Massachusetts to tell his story. And this becomes a very well-known episode in the kind of buildup to what becomes the sectional crisis of 1860 and 1861. So to kind of sum up, right, what I'm saying here is that there's this roiling debate in many different spheres about the rights of free African Americans in the United States, both at the state level and to some extent at this interstate level. The people who advocate for these rights have taken their best shot at making it a national issue and have more or less failed to do so, both because of people getting violently run out of the southern cities and because Congress isn't going to act. We see that there's some success in advancing this agenda at the state level. And that's kind of the impasse where things stood more or less until the rise of the Republican Party and the Civil War. So when I mentioned before that when we look at abolitionism, it's hard to trace direct lines from these radical abolitionists to what the Republicans actually did. That's not the case here. And these are just three of the prominent Republicans active during this time who were very, very involved in this first civil rights movement, who are on record supporting the repeal of the Black laws in Ohio, supporting Black men's right to vote in the state of New York in the case of William Seward, supporting the rights of free Black sailors in the case of Henry Wilson. These men were on the record engaging with these issues, and these become, in various ways, powerful Republicans during the Civil War and Reconstruction. And there are many more I could cite as well. And so what ends up happening, and now I am done with my slides and we'll try to unshare. So that's just that's giving you a taste of some of the things that were at stake and some of the ways that these debates unfolded. When Lincoln is elected in 1860 and a Republican administration kind of zooms into Washington, Southern states secede, giving the Republicans even more power in Congress. And what they see is they immediately begin to implement a policy of racial equality and civil rights. And some examples of that are the Lincoln administration, through an opinion of the Attorney General, declares that free African Americans are citizens of the United States in 1862. The Lincoln administration bars racial discrimination in witness testimony in federal courts, begins issuing passports to African Americans, which previous administrations had been unwilling to do, ends a ban on African Americans carrying the US mail, and a variety of other things that Republicans did in places where they believed the federal government had jurisdiction under normal constitutional powers. And then, so that is all sort of precursor to what they then do when they turn to legislation as the Civil War ends, right? So that brings us back to 1865 and 1866. They have already made it clear that they believe in repeal of policies that rendered African Americans second-class citizens, if you will, that discriminated in basic civil rights in places where they thought Congress conventionally or the US government conventionally had jurisdiction. And then moving into this period of constitutional change, they look at that and they think about how to nationalize it as they change the Constitution. And so that, though that I would argue in kind of broad brushstrokes, is the story of how this pre-Civil War civil rights movement feeds into what we know as these first federal civil rights measures, the Civil Rights Act of 1866 and the 14th Amendment. So I'm going to stop there, and I feel like I've laid out a bunch of different ideas. I'm happy to take questions on any of the things that I just talked about.
Thank you very much, Kate. It's a fascinating work and an important work. And I think the fact that you've focused both pre-Civil War and on North and the South is hugely important in our history for us to confront the issues that we still do today, to understand for example, racism is not isolated to the South, but existed in the North too. And so one of the first questions I had, and then we'll get to some of our the audience questions as well, is you had identified laws in the South and Charleston in particular, where there was an attempt to go to federal court to find, this is pre-Civil War, 1844, I believe you said, to find under federal law and Constitution unconstitutional, and it did not succeed. First of all, were the Black laws on the books in northern states pre-Civil War? And you're saying yes, and then if so, were any challenges made to those laws in federal court in the northern states pre-Civil War?
Right. So it's a good question. So the Black laws in the Midwest were on the books from the beginning of statehood. So Ohio becomes a state in 1803, and then in 1804 passes its first set of Black laws, which are actually anti-Black laws, right? And there are these kind of panoply, this raft of laws that are trying to, their worry when they pass these laws is about Black migration into their states. And so they pass these laws that are designed to discourage migration, make Ohio seem like a place you wouldn't want to move if you were leaving Virginia, now West Virginia, but right, if you think about that Ohio River border, and then make life difficult once you get there. And then so other Midwestern states proceed to pass these laws. Michigan has them, but less so. Wisconsin becomes a state much later and doesn't really engage in that, although none of those states allow Black men the right to vote. And so, and then New England states didn't have those laws, those kind of residency laws, nor did Massachusetts nor did New York or Pennsylvania. But in any case, so the question is, were they challenged in federal court? And the answer is no, because they were widely considered to be constitutional under the US Constitution. So the question is sort of like, what would have been the possible case you could make in federal court if you are, and the reason that if you're an Ohio Black resident or a white resident who objects to these laws, what is your claim? And I think sometimes people's imaginations immediately go to like the Bill of Rights, right? So we have this set of rights that are described in the Bill of Rights, enumerated in the Bill of Rights. But we have to remember that the prevailing view in this period, from the time of the American Revolution to the Civil War, was that those rights in the Bill of Rights were guaranteed against interference by the United States government, by the federal government, but not by the states, right? And because the prevailing concern of the people who wrote the Constitution and the Bill of Rights was about a strong centralized government, right? They were breaking away from England, from the British Empire. And so their main worry was about the overwhelming power of the US government. So most people, including in this famous case called Barron v. Baltimore, right? That was the kind of the case in which the court articulated this idea that these are guarantees of rights, not against the state government, but against the federal government. So if the state government takes away your property without compensating you, or if the state government deprives you of life or liberty without due process of law, that's not a federal concern. That's a state concern. And so that was the prevailing kind of idea. So if you're in Ohio and you think these laws are unjust, you don't really have a claim under the United States Constitution. You can make a claim under your state constitution. And people did talk about these laws as violating their state constitution, because all these states actually had declarations of rights that said that all people were, they sort of sounded like the Declaration of Independence. So sometimes people said that the Black laws violated the state constitution, but they would only be able to contest that, if at all, in state court rather than in federal court.
Wow, that's quite a muscular definition of federalism pre-Civil War. And were there any cases, state cases, though, that were brought in those states challenging the black laws under the state constitutions?
So one of the reasons that there weren't many,
Mhm.
and also they weren't successful, is because state courts tended to be very deferential to state legislatures. So if you have a state law, and also, okay, so if you have a state law passed by your legislature, it's hard to make the argument at that time that the court should declare it in violation of the state constitution, because it's passed by, the legislature, which is supposed to be the more democratic of the two bodies. But that being said, actually, so in Ohio, there's an interesting history of the Ohio courts shrinking the purview of the Ohio black laws in some areas. So for example, in Ohio, the courts, there was a question of who counts as black, right? The language that people tended to use at the time in these laws were that the laws applied to, quote, free Negroes and mulattoes. And so the question was like, well, what is a Negro? What is a mulatto? And the Ohio courts, in cases involving the testimony prohibition and also the right to vote, the courts said that anyone who was more than, quote unquote, more than half white counted as white before the law. And that meant that a whole lot of mixed race people got brought into the category of white and had all their rights, who, if the court had been more conservative on that issue, would have been considered black and therefore would not have had rights. So that's an example of a court narrowing the scope of these laws. Yeah, there's a case in Illinois in 1864. This is very late for these kind of things, where people test the constitutionality under the Illinois Constitution of the Illinois black laws. And the Illinois court upholds them and says that these are, because the other thing, just to kind of quickly, is that this goes to the question of the police powers of the state. So people tended to justify these laws by saying they were necessary for the safety of the state, that free African Americans were by definition threatening to the safety and security of the state. And so courts were also very deferential to those kinds of claims about safety and security, which of course, I think we would now think are completely, they're racist, they're completely objectionable. But at that time they would say, well, if this is what the legislature says we need to exercise the police powers of the states, we're going to let it stand.
Interesting. You mentioned Salmon Chase, Seward the third. I'm blanking on
Henry Wilson of Massachusetts.
Yeah. Thank you. And their activities, both pre-Civil War and post-Civil War. And Chase, of course, becomes Chief Justice in 1864. And I'm getting to questions now from our good audience. How does his early work in Ohio impact his time on the Supreme Court?
Well, that's a good question. It's a little bit beyond the scope of my book, so I don't have a particularly insightful answer to that, I'm sure. Chase was a really complicated and interesting figure because he, in Ohio in the 1840s and 50s, he was extremely aligned with this movement against the Black laws. He was a leader of the Ohio Liberty Party. He advocated Black men's right to vote in Ohio quite early on, considering, sort of white people's general views, as is widely known, right? He also, as a lawyer, defended the rights of fugitive slaves, tried to kind of argue that the Fugitive Slave Act of 1850 and the earlier one from 1793 were unconstitutional. And so he had a very, I would say, unimpeachable record from that era. But the more he kind of climbed the ladder in politics, also the more he had to conform to prevailing, sort of views of things, right? One characteristic of his time as Chief Justice, as I understand it, is that he continued to be, unlike some other Republicans, he continued to be more oriented toward limited power of the federal government than some other Republicans. And this also partly had to do with him, unlike many of them, coming out of the Democratic Party as opposed to coming out of the Whig Party. So he has a kind of complicated record over time. But I would say, there were few white Ohioans who did more to advance this cause than Salmon Chase did in the 1840s and 50s.
Um, did Black laws deny voting to Blacks in non-Southern states?
Yeah, so the Black men were permitted to vote in only a handful of northern states, and those tended to be the oldest states. So it's interesting that the states that abolished slavery and became states at the time of the American Revolution tended to have more racially egalitarian policies than the states that came into the Union later, like those Midwestern states. So Massachusetts, the New England states allowed Black men to vote without qualification, just on the same terms as white men could vote. New York famously allowed Black men to vote on the same terms as whites until 1821, when it created a new constitution, and in that new constitution made a property requirement for Black men while lifting all property requirements for white men. So now only the wealthiest Black men could vote in New York, while any white man of any standing could vote. And then Pennsylvania, another state with a pretty substantial Black population, which had allowed Black men to vote on equal terms before, from the time of the American Revolution, disenfranchised African-American men in 1835. And that was a very big decision. And a lot of people considered that, a very bad sign for the future of African-Americans in this country, because here's a state that's very identified with abolitionism, with kind of ethos of equality, going really obviously in the opposite direction. While at the same time, many Black activists, not only pushed back against disenfranchisement, but argued that Black men should be enfranchised everywhere. So even as Ohio repealed its Black laws in 1849, it did not explicitly enfranchise Black men, although Black men voted in some places in Ohio, and kind of because of these court decisions that kind of made race a little more ambiguous, and just because local officials sometimes permitted it. But really, as many people are aware, in the states where Black men had not voted, were not permitted to vote before the Civil War, they were only enfranchised by the 15th Amendment. So, it wasn't until ratification of the 15th Amendment in 1870 that African-American men were uniformly allowed to vote in places like Illinois and Pennsylvania at that point, and in other places. So whereas paradoxically, right, it's the 1867 Reconstruction Acts that forced the Southern states to enfranchise Black men as part of Reconstruction policy. So Black men get the right to vote in South Carolina before they do in Illinois.
Interesting. Oh. Another question from the audience. There seemed to be an increase in racist laws, more rigid support for slavery in Southern states, and as the 19th century progressed, what was the reason for that?
Yeah, so the Southern states increasingly cracked down on free Black people from a legal point of view, particularly in the 1850s. But really, so there's a kind of a little bit of a loosening of policies around slavery and around free African Americans around the time of the American Revolution. But then you see slave states increasingly kind of passing legislation that says they ban Black migration into the state, free Blacks. So they're saying, and then they force at a certain point, states start passing legislation that if you are manumitted or freed in a Southern state, you have to leave. So you can't keep living there. You have to leave the state and go somewhere else. And yet other slave states are passing laws saying no migration of free Black people into the state. And one of the things, so why, the question I guess is, why was that happening? White Southerners, people who owned slaves, were very fearful of the growing population of free African Americans. They saw it as a destabilizing force, right? Free Black people. Many times there were very close familial connections among people who were free and people who are enslaved. And free people could spread ideas about freedom. They could help people escape. They could bring abolitionist literature into the community. And so, they're all, as enslavers are becoming increasingly worried about the growth of abolitionism, particularly in the 1830s and later, and they're seeing free Black people or free people of color as vectors of danger who are very close at hand. And that's, I mean, one of the central reasons why they're becoming increasingly stringent in these policies. Just as an aside, I mean, one of the interesting things that I found when researching my book was that many times, particularly those lower Midwestern states, they would pass more repressive laws when they saw the adjacent slave states passing more repressive laws. So an example is like Missouri cracks down, passes newly repressive laws against free Black people in 1847. And then Illinois hosts a constitutional convention that summer, and they are talking about, you know, we need to have an even more repressive set of laws. And they're talking about being worried that people are going to be coming in from Missouri and Kentucky, you know, because their lives are increasingly difficult in those states. So in some instances, you see these dialogues between the states and increasing fears in these free states among some people, and responding in kind when they're seeing that the adjacent slave states are passing new legislation.
What led you to do this book? Where were you in your research? And how, it's a very important piece of work. I keep saying that, but it's true, I think. How'd you get there?
I'm not exactly, I'm not sure. I mean, but one way that I got there was I realized, well, this is one sort of straight line. When I was finishing my first book, which was on Reconstruction in Washington, D.C., and I was thinking about the fact that the Republicans, and this comes up in Until Justice Be Done too. So the Republicans in 1862, like a year into the Civil War, they moved to abolish slavery in the District of Columbia. And then without much debate, or really any debate that we know of, they also repealed the DC Black laws. So if they hadn't done that, slavery would have been abolished in Washington, but the same set of laws in DC that applied to like free Black people that said they couldn't gather without a license, they needed special licenses for certain employments, they needed to register with local officials. That whole set of laws that applied to free African Americans would have remained in place, right? And you would have had this kind of apartheid system. But the Republicans went ahead and not only abolished slavery, but in a separate measure, repealed those laws. And when I was finishing up that book, and I was sort of thinking, well, why would they have done that? Like so many of us, so many people think, well, the Republicans were just this, they allied around the idea of the non-extension of slavery. A lot of them were really racist. They didn't really believe in racial equality. It was, and kind of like, given what we know about the Republicans, it seemed like they wouldn't have necessarily gone ahead and just repealed the Black laws too. And so I was wondering, you know, I was sort of like, who wrote the book on that? What's the book I can go to that explains why that was the case? And I didn't feel like there was an adequate account of it. So I think I ended up writing a book that explains that in some ways. And so that was one reason, although I have to say that it wasn't like a straight line from like, I had this question and then I tried to answer it, because I went in many other directions.
Well, we're glad you did. It's very useful to the country, I think, important aspect of our history. And thank you so much for illuminating it. What's next? What do you have in the works, or what are you thinking about? You haven't gotten there yet, maybe, but you have an interesting pathway.
Well, thanks for asking, and thanks for inviting me to come and talk about the book with you all. I actually, maybe of local interest too, I have been working on a graphic history of Reconstruction in the Washington, D.C. region. So it's like it's kind of a cartoon history about the D.C. region, and coming back to Reconstruction, which I got, that's the period that I've always been, so interested in explaining and working on and trying to kind of convey what happened in this period that so many people kind of don't understand or forget about and what have you. So I'm really excited about that project. And it was a real pleasure and incredibly interesting for me to work with an illustrator, right? So, and this kind of synergy, and then seeing how she brought these stories to life in visual form was really fantastic. So that's been very satisfying, but that's kind of coming to an end, and I'm not actually sure what I'm doing next. So we'll see.
Well, keep up the great work. It's fascinating reading and important history. And we're glad you're doing it. Thank you, Kate. And thank you for your presentation today. I know our audience has enjoyed it. I will say, I'm going to give an advertisement. Copies of Until Justice Be Done, they're available from the Society's gift shop at www.supremecourtgifts.org. Great holiday gift. We encourage you to buy it and read it and study it. And thank you again for that. The Society's next, thank you. The Society's next virtual program is on Wednesday, January 11th at 7 p.m. when we resume our Civics and American Democracy series with Professor Scott Gerber, who will talk about the historical origins of an independent federal judiciary. January will also feature a conversation with my good friend, Judge Margaret McEwen, on her new book, Citizen Justice, an examination of the environmental jurisprudence of Justice William O. Douglas, and we look forward to that. Registration is open and available on the Society's website at www.supremecourthistory.org for both events. And a reminder, a survey is going to go out later this afternoon to everyone who registered in advance. Please do respond to it. We want to make these programs as illuminating and accessible to as many people as we possibly can. Thank you all for joining us today, and a special thank you to Professor Kate Masur. We are adjourned.